Welcome to the Window to the Law. In this edition, we are going to discuss changes that are coming to the real estate transactions starting on August 1st. On August 1st, all transactions must have the Integrated Truth in Lending Act and RESPA disclosures, or, as the rules are more commonly known, the TRID disclosures. There is a wealth of information on Realtor.org about these changes, including a new video by NAR President Chris Polychron. You can find these resources by visiting the RESPA page on Realtor.org. Therefore, I will only be touching on the highlights in this video and then focus on a topic that will affect Realtor Associations and real estate transactions in general, the purchase and sale agreement. TRID will create two required disclosures for real estate transactions, the loan estimate and the closing disclosure. The Consumer Financial Protection Bureau's rules creating the TRID were around 1,800 pages long, and so please note that there are many details that I am leaving out in this 5-minute video. The disclosure forms will range from 4 to 6 pages in a format set by the CFPB. The loan estimate is made once a consumer applies for a loan and must be sent to the consumer within 3 business days of receiving the application. The consumer then has up to 10 business days to decide whether to proceed with the transaction. The final loan estimate must be issued at least 7 days prior to the closing. The second disclosure statement, the closing disclosure, must be delivered to the consumer at least 3 business days prior to the closing. This document is intended to reflect the actual costs paid to obtain the mortgage, and so can be reissued after the closing to reflect minor variations at closing. As you have probably heard, there are a few things that can cause a reset in the 3-day waiting period: a change in the APR by more than 1/8 of a point, a change in the loan product, and the addition of a prepayment penalty. There are also certain tolerance limitations in the rule, meaning that if a consumer has to pay more for the loan within certain limits than were previously disclosed to the consumer, the lender may have to refund the difference to the consumer. That is a quick overview of the new disclosures. Now let's see how these changes will play out during the course of a transaction. On the screen, you can see the timing for a very basic transaction and how the rule's disclosure timing will alter the normal process. In particular, note in this scenario, the lender does not order an appraisal until almost 3 weeks after the buyer's offer was accepted. Because a lender can't charge any fees until the buyer has decided to proceed with a loan, this could delay the ordering of the appraisal and all other items usually paid for by the loan applicant. Also, note how the appraisal changed the loan-to-value ratio, which causes an issuance of a new loan estimate and a reset of the disclosure timing. As you can see, these new disclosure requirements will change the real estate transaction in a number of ways. First, it creates new timing requirements that did not exist before. The most important of these changes is the closing disclosure, as changes to the loan within 3 days of closing could cause a reset in the required waiting period and thus a new closing date. Second, the tolerance limitations and resulting refunds that lenders may need to pay will cause lenders to take more control over the transaction and so has the potential to slow down the transaction. So even changes that may not require a delay in the closing based on the TRID may still cause a lender to reset the closing date so that revised disclosures can be issued to avoid the tolerance penalties. So now you have some insight into how the new disclosure timing will impact a real estate transaction. For real estate professionals, the most important takeaway is a need to recognize that real estate transactions will take longer, and so they need to educate their clients about what has changed. In addition, clients also need to be educated about the possibility for closing delays and should be wary of scheduling back-to-back closings, as there is risk that one of the transactions may be delayed. Finally, real estate professionals need to help their clients understand that attempts at last-minute negotiations could derail closings, and so the parties should try to have all issues resolved well in advance of closing. In particular, changes made within the 3-day waiting period could cause a delay to the closing. Now let's discuss an important issue for realtor associations. Many of the form purchase and sale contracts used throughout the country are created by realtor associations or in conjunction with groups such as the State Bar Association. These forms are pervasive in the real estate market, and they serve as a basis for many real estate transactions. So how does the purchase and sale contract need to change? Many of the form contracts impose a duty on the buyer to close the transaction on a date certain. Since TRID or the lender may cause delays in the transaction through no fault of the buyer, purchase contracts need to be adjusted so that the buyer is not in breach of the agreement for not closing on a date certain through no fault of their own. Thus, the buyer's obligation to close should not be required on a certain date, since the potential for delays can cause this date to move. in addition to the buyer's obligation to close, all other timelines need to be reviewed. For example, short financing contingency periods may no longer be workable. As seen in the example, the buyer cannot be charged any fees for the loan except for the credit report until the buyer decides to proceed with the loan, which could take as long as 10 business days, and so items like the appraisal cannot be ordered right away. It is recommended that associations evaluate their forms with lenders and closing agents in their areas, as those groups will be familiar with how the rule will be implemented, and so will have insight into realistic timelines for a transaction. A few associations have already considered the changes that need to be made to their forms. Some have made changes to their forms by including language that the contract will be extended if the closing is delayed through no fault of either party. Others have found that their existing contracts adequately cover the delay scenario, as the contracts have already accounted for delays such as these. Finally, many associations have decided to take a wait-and-see approach before adapting their agreements, as they want to see how the new process works before adapting their contracts. Other issues will arise. For example, a lender group is looking for the inclusion of licensee information in the purchase and sale agreement, since this information is required on the closing disclosure. So this is another possible addition for associations to consider. As you can see, these new TRID disclosure forms are going to change the real estate transactions starting August 1st. Real estate professionals need to educate and prepare their clients for these changes, and realtor associations should review their form contracts in light of these changes. Thank you for watching this month's Window to the Law video, and we'll see you again next month.